Donald Trump and his defense file a motion to dismiss. They say that the charges that Jack Smith is bringing against them are unconstitutional because they are vague. You don't understand what they mean. You don't understand the content they're trying to regulate. What type of conduct are they prohibiting? What types of penalties are they prescribing? And so on. If you don't know what it is, then any prosecutor can just apply it to anyone for any reason at any time, and anybody can be prosecuted by a deranged thug who's not even a legitimate U.S. attorney like Jack Smith. And so Trump is filing to dismiss 32 counts, all of the classified documents counts in the Florida classified documents case. And so let's take a look at what this filing says. Filed in Florida, Southern District, the West Palm Beach Division. We've got the cases U.S. versus Trump and the co-defendants. And this here is President Trump's motion to dismiss 32 counts because it's unconstitutionally vague. And Trump's team tells us President Trump respectfully submits this motion to dismiss those 32 counts because those 32 counts are void for vagueness. Very common phrase in the law, and we're going to learn all about it. They tell us in a footnote, Trump reserves the right to supplement this. Perfect. They say, first of all, Judge Cannon, here's why. Section 793E is unconstitutionally vague as it's applied to Trump, a former president who's operating within the framework of the Presidential Records Act, who does the following, who one, acted as the ultimate original classification authority under the Constitution and has recourse to the executive privilege and is entitled to immunity for his official acts. He's operating within all of those things. Okay, he has all of these powers. And since at least 1941, courts in cases with less vexing features than this one, they've acknowledged the grave infirmities of the statute 793E under which Trump has been charged. And they've endeavored to save the statute by reinterpreting it to fit the case. Now that approach is inconsistent. You can't just manipulate the law. Inconsistent with due process principles and separation of power concerns that animate the vagueness doctrine, right? The danger here is if you have a statute that just says, you know, it's illegal to do bad things all the time. That's the law. What? Bad things? What is that? Well, don't do it. If you do it, you're going to be in big trouble. And so that's kind of what these laws are. And honestly, a real world principle of this is the disorderly conduct statute. Look it up in your home state. What does disorderly conduct mean? It's like the most generic term ever. It's like you were acting in a disorderly manner to disturb the peace and well-being of someone else, essentially. It's like that vague. Happens for everything. They just show up, couple gets in a fight, disorderly conduct. What? Your neighbors heard something. Okay. So it's just, what do you know, and they just arrest somebody for it. And it's just, you know, our government acting as totalitarian dictators. They just show up. You're going to jail today because we're the cops. So the point is, right, it's void for vagueness. These are loosey-goosey statutes, and Jack Smith is exploiting them to go after Trump. Now, it is not for Article 3 judges like Cannon or Chutkan to address the deficiencies in language chosen by elected officials. So courts, you don't fix them when Congress screws it up. You just say whether it's valid or not. That's it. Don't fix it. Particularly whereas here, the legislative records strongly suggest that there was no consensus meaning attributed to the problematic language. They say there were various judicial efforts to save the statute by attaching broad interpretations to a criminal statute. We'll just read it openly in order to reach the conduct of the defendants that were hauled into court by overzealous and politically motivated prosecutors. Sound familiar? Now, the Supreme Court recently applied this logic in 3 cases, striking the residual clauses, and the court should do that here. And by the way, whatever the term unauthorized means in this section, we're talking about this word, what does that even mean? It does not encompass the document that's charged in count 19. And that's probably the one where Trump actually had the clearance still. For that document, there it is. Trump possessed a valid security clearance, and therefore, following the discovery on this issue, the court should resolve any factual disputes and dismiss the charge. So here's what they say. Some background on this vagueness doctrine. They say, you know, we can't have just generic laws. In our constitutional order, a vague law is no law at all. The vagueness doctrine, it rests on the twin constitutional pillars of due process and the separation of powers. Vague laws contravene the first essential of due process of law. And process means we all kind of go through the same thing, that statutes must give people of common intelligence, that's us, fair notice of what the law demands of them. If you don't know what the law is or what the law prescribes or prohibits or what the penalties are, how can you comply? Second, vague laws also undermine the Constitution's separation of powers. Yeah. And the democratic self-governance that it aims to protect. The vagueness doctrine is a corollary of the separation of powers. It requires that Congress, okay, not the executive branch or the judicial branch, it defines what conduct is sanctionable and what is not. Remember, we got these 3 branches, and the executive branch does not write the law. That's Congress. The legislature, they write the law. The executive enforces the law, and the judicial branch says what the law is. So if the judicial branch is writing the law and saying what the law is, then they have usurped Congress. They now do two things. Same thing with the executive. So they can't duct tape over a bad law. If Congress wrote a bad law, they got to fix it. So to satisfy due process concerns, Congress must ensure that a criminal law not only provides the kind of notice that will enable ordinary people like us, I didn't go to Oxford like Jake Sullivan did, to understand what conduct it prohibits, but also that it does not authorize or even encourage arbitrary or discriminatory enforcement. If you can just pop into anybody and just, oh, that's disorderly conduct, you're going to jail. It happens all day in this country, all the time. Then that is subject and ripe for abuse, as it is there. And here, right, it's even more, I would say, evident on its face because Jack Smith now he's criminalized unauthorized possession. Well, what does that mean? Because we thought that Joe Biden was in unauthorized possession. We thought Hillary Clinton was in unauthorized possession, and she deleted stuff. So it feels like we don't really understand what that word means because it's misapplied. It's obviously vague. Even the DOJ can't figure it out. This guy gets charged, this guy doesn't. So preventing discriminatory law enforcement is the more important aspect of the vagueness doctrine. So here's the statute. They say Trump was charged with this, 793E. They say as relevant to counts 1 through 32. Here's what they say. They say whoever having unauthorized possession, we're asking ourselves, there's like many justifications, that have any document that relates to the national defense or willfully retains it to somebody who is not entitled to receive it shall be guilty of a crime. And they say, okay, we're going to focus on these three statutes, these three portions of the law, number 1, number 2, and number 3. And they say section 93 and its neighbor E and D, the subsection, they say this is a case from a law review article from Columbia in 1973. So these, probably very smart people, Harold Edgar and Benno Schmidt, they wrote this back in 1973. They said, these sections of the, Espionage Acts are undoubtedly the most confusing and the complex of all federal espionage statutes. They say it's a 793E is a singularly opaque statute. And someone else said the legislative drafting is at its scattergun worst precisely where greatest caution should have been exercised. So in other words, when a statute is poorly written, you don't write a bunch into it. You don't give it a bunch of other meanings because now you're Congress writing the statute. So they say, well, here's the background of 793E. The progenitor was the Defense Secrets Act of 1911. So we go back in history. In 1911, there was an act, and the act prohibited the willful communication of knowledge concerning anything connected with the national defense to one that is not entitled to receive it. Now, the statute did not make mere retention criminal. Okay, so just having documents. So that's where it started. Then there was an Espionage Act of 1917. Congress passed some other things. In the Espionage Act then of 1950, Congress then split it into a couple sections, and now we have the statutes that we have here today. And so it's gone through a bunch of different permutations until it gets here. And this is what's so beautiful about the law. It's like there's refinements, Let's try it this way. Do these words govern this? That was a pretty bad idea. Okay, let's try this one again. How does this work? And then it's this constant, beautiful kind of symphony that happens between all of these different levels of our government. When it works well, it works well. And it's not working now because everybody's perverting their roles. Everybody just says, well, Trump. So we don't really need a separation of powers. Everybody can do whatever the heck they want all the time and no judgment at all. But I digress. Here's the discussion section. They say, all right, with all that background, they say, Your Honor, Judge Cannon, section 793E, which is what Trump has been charged with 32 times here, is unconstitutionally vague as it's applied to President Trump. Now, vagueness challenges matter. In this case, the statute's vagueness is subject to exacting scrutiny, meaning we got to be very, very specific on this. Get out your magnifying glass. We're zooming in. Because the special counsel's office is seeking to prosecute Trump based in part on his protected speech relating to the documents at issue. Now, section 793E is one of the vague statutes that threatens to hand the responsibility of defining crimes to relatively unaccountable police like Jack, to prosecutors and to judges. And the Supreme Court warned about that. As discussed in more detail, they say some courts have tried to save this broken statute and its predecessors, and they tried to make it not unconstitutionally vague. This is the courts like, can we do to not dismiss this case against this defendant, right? All the institutions will circle the wagons, they'll bring out their duct tape, and they'll fix what Congress did because they're like, well, Edward Snowden's a bad person or something, whoever that person happens to be. And so they just recreate it, totally unconstitutional. They make judge-made rules and judicial glosses, right, to plug the holes. However, the role of our courts under the Constitution is not to do that, not to fashion a new, clearer law to take its place. That's for Congress. All they should do is treat the law as a nullity, say, hey, morons in Congress, you guys are dumb. Rewrite it again. And that would actually be a good way to get Congress to work again. Instead, the courts just fix everything for them. Just send it back and say, you guys don't know how to write. This obviously doesn't make any sense. Try again. And if you want this power, justify it and invite them to try again. Now, it would certainly be dangerous if the legislature could set a net large enough to catch all possible offenders and leave it to the courts to step inside and say who could be rightfully detained and who should be set at large. Back to my original example. They write a law, don't do bad things or else you go to jail. And then they just let the courts sort it out. So then the courts are kind of writing the rules for what the bad things are. That's obviously insane. Now, because that is what Congress has done with Section 793E 3 times, they keep trying to modify it. And because the judicial efforts to keep the statute on the books are inconsistent with the court's reasoning on vagueness in these 3 other cases, the court should then reject these authorities and find that this statute is void for vagueness under the circumstances of this case. And this case does bring in some additional variables. Trump was the former president, obviously, and there is, as applied, like it might not be vague if I've got classified materials. Like, oh, Rob, you shouldn't have those. Like, for example, if I was a senator and I had classified documents in my possession, there's really not a good justification for that, unless you're an elderly old man who can't remember things or whatever, Robert Hur said. It's not that vague. But when you're the president and you've got declassification power, you've got the ability to clarify, to classify your documents as personal records rather than presidential records, when you've got all sorts of other powers, it makes it more vague, because how the heck can that apply to you when it's legal for you to do this stuff? So they say the authorization clause, right? What is this unauthorized possession? They say, first of all, that specific phrase is unconstitutionally vague as applied to Trump because the pertinent language fails to provide any guidance about its scope, how big is the hula hoop, and it permits arbitrary enforcement, as we're seeing here today. They say there is far too much indeterminacy around the meaning of what is unauthorized possession, especially with respect to Trump. What the heck does that mean? It's like, what does disorderly conduct mean? Like you get into an argument, that's it? The documents that are the focus of counts 1 and 32 are only allegedly classified because of Trump's original classification authority, which is derived from Article 2 of the Constitution. And he wielded that pursuant to his power from the people's mandate in 2016. And he delegated it as Trump saw fit for Executive Order 13526. He had the power to do all this stuff because he was the president. He wasn't like, kind of like 98% president. And they say, well, he couldn't do all those other things that the other presidents could do because Trump. Nope, 100%. They say past presidents routinely took national security files here. Robert Hur even mentioned that in his report. That's weird. And no one suggested that their possession and their retention was unauthorized, as we've talked about in our vindictive and selective prosecution motion, which we're still waiting to get our hands on because that was filed under seal. Now, the Constitution gives the executive a large degree of power, and they give that executive the power to preserve their own internal security. Continuing, Trump's defense says, Cannon, in addition to Trump's constitutional authority and the DOJ's established practices that came before this case that suddenly all changed, presidential discretion to designate records as personal under the PRA adds additional ambiguity to this, as we talked about in a prior segment here when we read through the Presidential Records Act motion to dismiss. Another good filing. Now, the non-criminal nature of the PRA, the Presidential Records Act, Trump said, right, under the act, I have sole exclusive authority to declare this is a personal record. What's the precedent for that? Bill Clinton. He did the same thing when Judicial Watch tried to sue him. So if Trump has the sole authority to say it's personal, it's outside the purview of the National Archives, it's not a presidential record, that automatically makes it not criminal. And that adds some questions about whether or not it really is unauthorized, right? So it's another layer. So even if the authorization clause, even if that little phrase there gave adequate guidance to President Trump, and it did not, obviously, the vagueness of the phrase unauthorized possession as applied to the president, it also gives and lends to an impermissible risk of arbitrary enforcement. We see here, there are numerous examples of other cases in similar situations where the government brought no charges as discussed in our other motion, which we really want to read that one. And they say, by the way, also, what does this mean? Relating to national defense. This is also vague in the statute. The NDI clause unfortunately provides no guidance on the question of what kind of information may be considered to be related or connected to national defense. Pretty big phrase there. The NDI clause is the National Defense Information Clause. What is that? Quite broad, potentially too broad, especially in the time of war, because any information could conceivably relate to national defense. Wow. And that is a foreboding phrase there. That comes from the Fourth Circuit. Yeah, this Rosen case is where it comes from. Now, get ready for that, my friends, right? This is what we're going to be living through in 2024. You can already see the pillars being erected all over the place and the state media, that we are going to be in a time of war. It's all Western democracy versus Putin. And any information that could contribute to Putin and his success is now going to be a threat to the national defense. So we're quite frankly going to be living this, I think, in real time right now. And they're doing it, right? They're applying it to Trump. He had the same documents, probably less serious documents than Hillary, than Joe, than Pence, than all the others, but they're prosecuting him because it's so broad that Trump is now this arm of Putin, and it's not going to stop there. Wait until they start censoring the rest of us. So provide such guidance in connection to the amendments. They say elected officials have failed to agree on the language that provides the adequate notice of what is defense information. And the court should not save this prosecution because the statute is problematic. Saying, Canon, there is no binding authority to address the defective clause that Congress wrote in there. They say here, this section comes from this provision, and the Supreme Court interpreted this. When they were talking about vagueness in constitutional concepts, they said, we find no certainty in this statute, which deprives a person of the ability to predetermine whether a contemplated action is criminal. The obvious delimiting words in the statute are those requiring intent or reason to believe that the information to be obtained, here you go, is to be used to the injury of the United States or to the advantage of any foreign language. So in other words, it's not just mere possession. It's used to injure or to the advance a foreign nation. Section 793E contains similar language, but however, prosecutors typically argue that this injury language doesn't apply to the charges that are based on documents. They just say, no, possession of the documents is just enough. Now, assuming the special counsel's office adheres to that position, that case still does not address the vagueness defect in the clause. Now, 4 years after the Supreme Court made a decision in that prior case, the Second Circuit explained that the NDI clause, well, it can't be taken literally, is what they said, right? This is the court, again, bending everything. Why? It's written down. They say it seems plain that the section cannot cover information about all those activities which became tributary to the national defense in time of war. For in modern war, there are none which do not, right? You have like a mainstream of the national defense information. They're using river analogies. You've got a tributary that is sort of branched off there, right? What decides? I mean, we got censored here after January 6th for harmful and dangerous misinformation. Were we attacking the national defense, right? It's just a stone's throw away. These people are nuts. So they want to do it here. Now, Congress failed to address these vagueness concerns in connection. Congress didn't make any modifications. They had every right. Congress knows that, there were prior problems with this bill and with this concept, and they rewrote it several times and they didn't figure it out. So based on this reasoning regarding different statutes and reported decisions, they've applied a judge-made requirement. They try to save this statute from the fatal vagueness problems that it presents. Now, these rulings are in significant tension with other Supreme Court guidance, right? This is how these things pop up. The Supreme Court talks about vague laws in a million other cases, and they have guidelines for that. This is vague, this is not vague. So then this one pops up. They have to reconcile the two. And they haven't done that. So how come the courts are duct taping this statute to make it valid when the vagueness rules say it should go? Well, it's because they don't want, they're trying to cover for Congress. They don't want to dismiss charges against people that have Espionage Act violations. And you might agree with that, but they should be holding them under valid laws, not judge-made Band-Aid laws. So they continue. They say, thus, it might have been a good idea for Congress to fix this stuff, but that doesn't tell us whether Congress actually did. The NDI clause that Congress wrote is unconstitutionally vague because we live in an era where every facet of civilian life may have an important bearing on the nation's military capabilities. Obviously, right? I mean, they put a memer in jail for election interference. What are they going to do if things really get hot in this world? And they say, oh, your tweets are now Putin, extensions of Russia or whatever. And they just get to apply the law to anything, to everybody. That's dangerous. That's harmful misinformation. You're a Russian propagandist. And we saw that, right, some time ago. Now, accordingly, the NDI clause is fatally vague in its own right, cannot be saved through judicial gloss, and it contributes to the overall impermissible vagueness of 793E. They continue saying the entitlement clause is also unconstitutionally vague as it applies to Trump. The phrase offers inadequate guidance. There are no enforcement standards, and we don't know who would be entitled to receive those records that a former president has already designated to be personal. And the PRA, the Presidential Records Act, grants him virtually unreviewable decisions backed by Article 2 authority. And we've read that filing previously. Now, in another case, the Fourth Circuit rejected an argument that Trump did not make, and the court here should reject reasoning in other cases because those cases involve much more than a gloss, right, to just fix this stuff. They say a type of interpretive gloss is, you can do that, sure, I guess, but Morrison exceeded those bounds. They violated the separation of powers, and they read into the statute an implied rulemaking delegation by the executive branch. So in other words, they said, well, I guess what is unauthorized, we'll just let the executive decide. Wrong! The executive branch, which enforces the law, the court is basically saying, we'll give the prosecutors some discretion, and they can make rules, and rules will provide notice, and then the whole thing is fixed. Wrong. Unconstitutional. Congress needs to do that. Such a delegation is only valid where Congress lays down a legislative act that decides. And Congress knows how to do this. exists. It's their whole reason for existing. The 11th Circuit rejected a vagueness challenge to another statute, and the Attorney General promulgated some other thing. But that was a different situation here. And so even if the court wished to do what Congress has not done by looking to the executive branch for guidance from them, Executive Order 13526 is insufficient. For individuals seeking to comply with that executive order, it provides no relevant guidance on who is entitled to receive the documents, whether anything is excluded under the Presidential Records Act, and so therefore it raises the same unreviewable questions as in prior arguments where the records were personal, not presidential. Now, if you define the entitlement clause and reference, in other words, you take the statute and connect it to an executive order, then you have these need-to-know bases, and this phrase is just as vague. And so it's still, the executive then still provides for a harsh and discriminatory enforcement capability by local prosecutors, and that's unconstitutional. And so therefore, this law is unconstitutional because it confers unfettered and wholly subjective enforcement discretion to the executive branch. They don't get to write the laws and then enforce the laws. That's Congress. And also they talk about willfully. We talk about this a lot, mens rea. So in criminal statutes, you have two components, mens rea and actus reus. Mens rea is the guilty mind, what's happening in the brain, what's happening in your mind. It's your intention, it's your recklessness, were you acting negligently, what's in your brain. Then you have the actual act. What was the thing that was done, right? The physical movement of an object or the attack or whatever. So you have the two, you got to define both of them. That's how you get criminal convictions, by proving the both of them. Now, willfully is a word of many meanings, right? What does that mean? What does reckless mean? What does negligent mean? What does knowingly mean? What does willfully mean? Thus, the presence of a bad purpose or evil intent alone may not be sufficient. So here in this statute, even if the term willfully could be said to address the vagueness doctrine's fair pillar, and it cannot, the intent requirement does not mitigate the arbitrary enforcement problem. And so it's not enough to argue, as prosecutors have, that Trump will only be convicted if criminal intent established at the trial. No, they say jurors are then relying on the vagueness doctrine, right? The jurors then look at the rules and they say, I don't know what that means. And so the jurors just apply a vague law and they charge and convict the client. So accordingly, counts 1 through 32 must be dismissed. And of course, count 19 must also be dismissed because Trump had security clearance at that time. And so in conclusion, Trump's defense says, for the foregoing reasons, President Trump respectfully submits that these espionage statutes are garbage, okay? They are unconstitutionally vague. No one knows what the heck they mean. The executive branch is trying to bubble wrap them, duct tape them up, plug all the holes in them. Courts have been deferring to them with discretion for some period of time, but that is unconstitutional. Congress writes the rules. You don't want a country where the executive writes the rules and then enforces the rules and then judges the rules too, which is what they're trying to do here. That's called a dictatorship. So they say President Trump, counts 1 through 32 and count 19 all must be dismissed, count 19 in particular, because Trump did have a security clearance. And so the court should resolve these disputed issues of fact for counts 19, but dismiss counts 1 through 32, void for vagueness and unconstitutional. Signed by Trump attorneys Todd Blanche and Christopher Keese in the House, sent in on the Florida classified documents case. And obviously, I think it's a good argument. I don't know that the judge is going to bite on this one, but I do think it's a good argument. You know, courts are very deferential to Congress and to other precedent and to other courts. It would be good if Cannon did that, but this might be something for a higher level court to deal with, right? In other words, Cannon would say, well, I'm not going to overturn all these different circuit precedents, and she is not going to want to be the one responsible for opening the floodgates of espionage prosecutions being dismissed, right? If she comes out and says, well, you're right, unconstitutional, 793E is a problem, there's going to be consequences for that, which is why no one wants to do it. All the courts have been protecting this statute for years, decades, coming up on a century maybe, because they don't know how to handle it, and they're just trying to stop the ship from sinking. So if Cannon comes out and says, sorry, unconstitutional, there'll be some consequences for that. So what she may do, what I think is more likely, deny this motion. Trump will probably appeal this. We'll see what the 11th Circuit does, and then maybe what the Supreme Court does. And this is something much more likely that the Supreme Court fixes and deals with when it gets there. So it's a great motion. I think that we have seen a lot of this type of governance that has evaporated the proper balance of power that exists, and it's allowed these prosecutions to become unbounded, essentially, because they're just prosecuting whoever they want, which is what they're doing against Trump. So very great motion. We're excited that that one is working its way through the system in Florida. Now we're bringing on Andrew Weissmann, a former Trump prosecutor. He, of course, is on the blue team on the other side, and he is responding to a new motion that Jack Smith filed, and Jack Smith was responding to Trump's motions. And so let's see what they're saying over there on MSNBC and what they're talking about Trump.
I'm so glad that Carol brought it back to the national security implications of this, because I think we get lost in, Eileen County Cannon as, Carrie Lake-ish, or Eileen Cannon as a real, we get lost in what's happening in front of us. One of the advantages of stepping away for a minute, someone says Mar-a-Lago and you think, oh my God, stars on the wall. You think Sue Gordon. You think people died to get a scrap of evidence, or a scrap of evidence from another country's intelligence professional to share with our government with the trust that it won't be tossed in a box. And it wasn't just with other documents. It was with his underwear, so said Trump. The disdain for the documents and everyone.
The FBI went through Melania's underwear drawer too there, woman.
And everything and every life risked to gather them is always stunning to me when we come back to this one.
When you think about what the election was about in terms of empathy being displayed by then, candidate Biden, and the lack of empathy with respect to Trump, it wasn't just sort of abstract principles that were being talked about, or even with respect to just how they deal with people. That lack of understanding what your obligation is, aside from yourself, is what leads somebody to not take classified information seriously. I'm not talking about making a mistake. That could be said about Mike Pence, Joe Biden.
Yeah, and that's what Jack Smith talks about. This is not inadvertent. This is not willful, but not malicious. This is something in a next level.
Exactly, because it was over and over and over again. There was no question that it was intentional for months and months, and then on top of that, obstruction.
Oh my gosh, he invited the FBI over, okay? The FBI, he waved to them. He walked into the same conference room. They were there investigating him. They were there scoping out all the security cameras. And he's like, hello, FBI, how can I help you? Would you guys like some lemonade, right? This was the part of the unwinding. He was negotiating with them. There was a back and forth. He was processing the documents. He didn't realize that the FBI was going to be surveilling him and building a case against him on illegitimate charges. Again, totally vague. He didn't know what the conduct, as far as he knows, the precedent was Hillary Clinton can smash cell phones and destroy evidence with BleachBit software, and the FBI doesn't care at all. So we're going to, of course, continue to cover this classified documents case and continue to reveal more about this disgusting prosecution, and we hope that you join us as we do. So my friends, thanks for subscribing wherever it is you're watching this. Thanks for checking out some of the links down in the description below. We have watcherlodge.com, where we have amazing events happening. We also have all the PDFs are online at robertgovea.com, and of course, watchingthewatchers.locals.com is where we have our members only community, where we do streams in the morning and on Saturday, and we'd love to see you there.